Experienced Miami slip and fall lawyer, Charlip Law Group LC, injury lawyers. Every year in the United States, millions of individuals are injured in slip and fall accidents. Injuries caused by falls are now the leading cause of accidental injuries. According to the National Floor Safety Institute, fall accidents now represent over 8 million emergency room visits, resulting in estimated costs of between $13 to $14 million annually. In the U.S., 1 out of every 3 individuals over the age of 65 will experience a fall accident. Especially when these accidents involve older adults, they can cause serious injuries and, sometimes, fatalities. Unfortunately, proving fault and negligence in a slip and fall case can be extremely difficult in Miami. When you have been injured in a slip and fall accident, it will be very obvious to you what caused the accident. But as in all personal injury claims, what may seem obvious to you may not be as simple as it seems. Slip and fall accidents can happen anywhere where people walk and congregate. They can happen nearly anywhere, including malls and shopping centers, grocery stores, bars, nightclubs, and restaurants, hotels and motels, public parks, parking lots and sidewalks, recreation facilities, theme parks, gyms, office buildings, apartment buildings, swimming pools, elevators and escalators, workplaces, construction sites, government buildings, private property. If you were injured on another party's property, whether a business, municipality, or private property, the owner of that property may be held liable for your injuries. At Charlip Law Group, slip and fall attorney David H. Charlip and our team of personal injury lawyers understand how overwhelming it is to deal with insurance companies when it comes to receiving compensation. Miami slip and fall accidents fall under Florida's common and legislative premises liability laws. Under our laws, the owner or tenant of a property has the responsibility for keeping the property or premises reasonably free of hazards. This can include having security cameras in place or well-lit parking lots to ensure that individuals who come to the business are safe from harm coming to or leaving the premises. If they have failed to do so, they may be held liable for any injuries and damages that result. Under Florida law, any visitor who has been invited onto a property for social or business purposes is considered an invitee. This can include shoppers, visitors to commercial office buildings, visitors to public places, or even social guests. Anyone who is on a property for purposes that directly benefit him or her is considered a licensee. A property owner must still protect anyone who is considered a licensee from hazards and potential injuries on that property. Anyone who enters a property unlawfully or without permission is considered a trespasser. But even trespassers are afforded some level of protection from dangerous hazards. A property owner still has legal responsibilities to post notices of any dangerous conditions, keep their property in a reasonably safe condition, post no trespassing signs to indicate private property, post other signs designating a possibly dangerous condition, not intentionally or unintentionally create or allow a hazardous condition on their premises. The exception to the trespasser rule is when children are harmed on someone's property. Even if a child has come onto a property uninvited, the property owner may be held liable for any injuries that result. Our state is home to the highest percentage of seniors in the country, at 21%. Slip and fall accidents affecting older adults can cause very serious injuries, often requiring surgery and hospitalization. Nursing homes and retirement communities can be held liable when an elderly resident has suffered injuries in a slip and fall accident. If an older loved one has suffered a slip and fall accident in a nursing home or retirement community, it is critical to get the help of the Miami lawyers at Charlip Law Group. Proving negligence in a slip and fall case can be complicated. In Florida, an accident victim must prove certain things to prevail in an injury case. To prove negligence requires the proof of each of the following elements. The property owner owed you a duty of care. By allowing the hazard to remain, the property owner breached that duty of care. The breach is what caused your accident and injuries. You have suffered damages as a result of that accident. While many falls can be mere accidents, many are the result of the property owner's or tenant's negligence. Common causes of slip and fall injuries can include flooring that is slippery due to spills, Cleaning supplies, and lack of maintenance, any property owner has a legal responsibility to keep their visitors safe from harm. Unsecured flooring, rugs, carpets, flooring that is unsecured or improperly maintained can present a safety hazard for anyone in the vicinity. Uneven floor transitions, a change in depth or type of flooring that is unexpected or unmarked can result in safety issues and lead to serious slip and fall injuries. Improperly maintained sidewalks, parking lots, or other walkways. Most sidewalks in Florida are part of the public domain and are typically the city, county, or state's responsibility to maintain them. Inadequate lighting, well-traveled areas, walkways, and parking lots that are not properly or adequately lighted can result in missteps causing accidents and injuries. Broken stairways, handrails, and inadequately maintained stairwells can present safety problems for those who must use them. Clutter and debris. Clutter and debris that has accumulated in an area used by others can be safety hazards for those who navigate the area. Lack of barriers and warning signs. Sometimes, hazards are unavoidable. In many slip and fall cases, negligence is the reason for these accidents, and the owner of the property is legally liable for any accidents that result. Regardless of how or where you fell, hitting the floor or ground abruptly can result in serious injuries. Broken bones. Slip and fall accidents commonly cause broken bones, with the elderly particularly vulnerable to serious bone fractures. Cuts and lacerations. Falling on glass, debris, or other sharp objects can result in serious cuts and lacerations, sometimes causing scarring or long-term damage. Spinal cord injuries. Serious spinal cord injuries can result from fall accidents that affect the vertebrae, discs, and nerves. Neck injuries. Neck injuries may result from damage to the spinal cord or muscles, ligaments, and tendons in the neck. Concussions, a milder form of traumatic brain injury. A concussion can happen when the head collides with a ground or hard surface. Other traumatic brain injuries. Many other types of traumatic brain injuries can vary in severity and intensity. Facial injuries. Falling and hitting a hard object or surface can result in serious cuts, broken teeth, jaw fractures, and eye injuries. Chronic pain. Much injured slip and fall accident victims can go on to live with debilitating chronic pain for years. Call us today at 305-354-9313 to speak with our experienced Miami and Florida attorneys. Another important aspect of a slip and fall case is comparative negligence, or the concept that you may have shared fault for the accident. If the property owner can prove comparative negligence, your compensation will be reduced by the percentage that you shared fault for the accident.